All right, folks, buckle up. Right off the bat, we've got a classic DWI case. And we're diving into the tense moment when the defendant realizes jail might actually be on the table. Ever wonder what probation really means? Stay tuned.
You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. Is this right? You look confused.
No, he's only expecting the probation. He knows that he's not going to have to go to jail.
Right. So it's 180 days in jail. I probate that for 18 months. You will not go to jail as in this case. As long as you fulfill conditions and you do everything you're supposed to, you don't test positive. We all do backflips. What goes wrong is when you don't do what you're supposed to do. You pick up a new case.
Sorry, the offer was for 15 months. I think I made a clerical error and wrote 18 months instead.
Is this correct?
Yes.
Okay, so we'll fix it.
Sorry.
That's not a big deal.
Okay.
Let me ask you this. Was there an accident in this case?
There was, yes. Well, he was asleep next to the train track. So yes, he was off of the road and had crashed through the train track.
It was his own
Single
vehicle.
Yeah.
Okay, so there's no restitution to someone else?
Yes, sure.
That's my concern.
Yes.
Okay, because my concern is that if you do something to yourself or your vehicle, I don't care. If you do something to someone else, then I care. Right. So hopefully, lesson learned, right? Hopefully, you don't get to where some people only learn the hard way. They got to hit rock bottom. They don't get it until they go into here. Right? You've worked out an agreement. They're offering you a 15 month. You want me to?
I'll figure it out right now, Judge.
It's a 15-month probation. You need to understand that this DWI will go on your record. It's going to be there forever. You can never take it off. And this is important because from now on, I don't care if it's a year, 2 years, 10 years, 15 years. If you get pulled over, officers will see that you're a prior DWI. If you smell like alcohol, if you smell like dope, it's probably not going to go well for you. From now on, after today, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand, Mr. Roberts?
Yes, sir.
For you to successfully complete this program, you must first do a TRAS. This is an evaluation to see what conditions you may need. If they assess other conditions, you must fulfill them. It could be supportive outpatient treatment. It could be, intensive outpatient. I don't know, but we have clinicians that will interview you to determine, is this the right type of program for you? What you must do is a DWI education class, 4 victim impact panels, no drugs, no alcohol, and a guardian interlock and a random urinalysis. Is this how you understand the agreement?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So that's why I said, because you give up this right to appeal, once you accept this agreement, there's no turning around. There's no, you know what, I changed my mind. I want to do something else. This isn't Target. You can return it. You understand? The other thing I want you to understand, Mr. Roberts, is that we all make mistakes. The idea is that you learn from the mistake. And the reason I'm telling you this is that DWI is humongous business in Texas. There's a $3,000 surcharge that attaches to you when you pick up a DWI. If you have a 0.15 or above, it's a $4,500 surcharge. If you don't pay it, you do 1 day in jail for every $100 that you owe. You asked me to waive this.
Yes, Honor. There's a bit of a confusion because when I was talking to the district attorney's office, they said that they would waive the fine. So is this a different? Yes, sir. I'm sorry. Yes, Your Honor, of course.
The point that I'm trying to make, waive it. This is a first offense. We all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI, it's a $6,000 surcharge. And a 30-day minimum jail stay. Do you understand?
Yes, sir.
So if you want to get lit, if you want to have 52 shots of tequila, 35 joints, just don't get into a car. It's not hard. After the probation, can't do it now. Do you understand?
So,
All right, how do you plead to the offense, sir? Guilty or not guilty? I'm gonna find you guilty. I'm gonna follow the agreement. Can you look for his license to see whether it's suspended or not suspended, please?
Yeah.
I'm not gonna suspend your license. I don't know if your license is suspended now, though. We're gonna look it up to see if it is.
It is suspended, Your Honor. It's not illegal.
Okay, so
He needs to just pay a reinstatement fee of $125 for him to.
is there an ALR suspension or no? You're not allowed to drive.
It is an ALR suspension.
When does it run, do you know?
Until
So
We anticipate filing a request for occupational driver's license.
you can't drive now. If you drive, and I don't care what you got to do, I don't care where you got to go, I don't care if there's a burning building, you have to save 50 kittens. Don't drive. If you do, you're in violation of this probation. If you drove here, you cannot drive home. Do you understand? Don't do it. So I'm happy, file it and we can talk, but
Okay.
don't drive until you either get an occupation or get the license back. Do you understand? So because of that, he'll get a portable device. All right. Good luck to you, Mr. Roberts.
Thank you, sir.
Thank you, Mr. Farrar.
Thank you.
Good luck. You don't take things seriously. You don't take us seriously. You had your first bond violation report the beginning of March for failing to go take a drug test. And now a new one was filed because you now picked up a new case. We are going to do probable cause on your new case. You now stand charged with the offense of criminal trespass. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. As you see, your lawyer is here with you on Zoom now. Please.
on March 19th, 2025, an officer was dispatched to an assault in progress, unknown weapon at City Plaza condominiums in Harris County, Texas. The complainant, a security officer, stated that she saw the defendant walking around the security office, which the complainant found unusual. The complainant stated the defendant went near the exit gate and was waiting for someone to come and exit through the gate. It was waiting for someone to come and exit the gate so he can get inside the complex. Complainant stated someone exited from the gate and the defendant got into the complex. The complainant followed the defendant and told the defendant that he needs to leave the property because he was criminally trespassing at the property. The complainant stated that she told the defendant several times to leave the property, but the defendant did not listen. The complainant stated the defendant laid on the ground, the defendant stood up, the defendant started taking pictures of witnesses, and the complainant came in between witnesses' motor vehicles, so the defendant could not take pictures of. The defendant was identified by his Texas driver's license.
So at that point, do the cops come up there and they just arrest him there? Does it say? Does it take off?
Also, it does not state in the DIMS at what point he was arrested. Also, something that was missing from the summary was that a witness stated she saw the defendant punch the complainant and then they had a fight.
He punches someone.
That's what the DIMS states.
Mr. Gomez, I'm going to find that there's sufficient probable cause to go forward with your case because of your failure to comply. Repeated failure to comply with your bond conditions. I now revoke your bond. He goes with you. James, I will leave the criminal trespass bond as is. The DWI now is at 5,002 and will stay at 5,002.
Yes, Judge. So he has a PR bond on the criminal trespass?
I don't. Let me see. No, he actually made a surety bond on the trespass. So I'm going to keep that as is.
Okay, thank you, Judge.
Other case will, so Kayla, I need you to do me a favor on bond conditions for him. If he is released, he's to be released with a GPS monitor and he's not to go anywhere near the complaining witness and nowhere near this complex, 500 feet, please.
Yes.
On the trespass. All right, good morning, Mr. Sims, right? Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 16th, 2025, at 929 Gessler Road in Harris County, Texas, the Memorial Herman Tower NICU.
Boom. Here's a turning point. Judge isn't messing around. If you break the rules, it's straight to jail. Probation isn't a free pass. It's more like walking a legal tightrope. One misstep and it's game over.
The officer made contact with the complainant. The complainant stated the defendant, the father of the child, was staying overnight at the NICU with their child. The complainant stated that when she arrived, she observed their child to be in the bed with a blanket fully covering the child's face. The complainant stated that she pointed this out to the defendant, which upset him. The complainant stated that she then asked to remove the blanket from their baby's face, which the defendant refused. The complainant stated that she then moved towards the baby carriage to remove the blanket, to which the defendant stepped in her way and pushed her back. The complainant stated that she reacted by pushing him back. The complainant stated that the defendant then cocked back his arm and punched her in the face with a closed fist, striking her on her left forehead near her temple. The complainant stated that she felt pain from the punch. The complainant stated that the hospital staff overheard the commotion and escorted the defendant off the premises. The officers observed a small mark on the complainant's forehead where she stated she was struck.
Okay, Mr. Sims, I'm going to find that there's sufficient probable cause to go forward with the case. It appears a protective order has been issued. I would get to know it. If you do something to violate the protective order, the state can and will probably file a violation of the protective order against you. It's one of the worst cases you can pick up. Do you understand?
Sure.
Do we know whether she wants to have contact with him or not?
We have not been able to make contact.
Okay, I don't know if she wants to have contact with you, so at this point in time, I'm going to order you not to have any contact with her and not to be in possession of weapons. If you violate this, I will revoke your bond, put you in jail. I will do everything in my power to protect every single person in this county. Do you understand, Mr. Sims?
Yes, John.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Ms. Wright, and she will tell you if and when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, you're ducking and dodging phone calls, I will issue a warrant for your arrest.